Hello and welcome viewers and subscribers of AVT News. I hope I find you well in your different locations wherever you are. My name is Olisi, the son of Nobe, and as we promised on our Facebook page, we are here to just go through a petition, the legal petition that the Citizens Coalition for Change, that is the mainstream Zimbabwean opposition party, led by Advocate Nelson Chamisa, has drafted for presentation to the SADC, that is the Southern African Development Community, in as far as the Zimbabwean elections are concerned, or in as far as their dispute over the outcome and the handling of the Zimbabwean election is concerned. Now, I have to state this clearly. We haven't yet received confirmation that indeed this is the actual petition of CCC, but we have been given this by our sources within that particular party, that this is the basis of their application or of their petition to the SADC, arguing for an election rerun in Zimbabwe, or rather the holding of fresh elections, which to them are supposed to be underwritten or scaffolded, as per the word that was used by their deputy spokesperson, Gift Ostalos Sisiba, by the SADC and or the African Union. So I'm going to go through the full contents of this draft petition, and then we're going to briefly review it because it's a very long thing. It's 5 pages long, and then as we go along, you are allowed to use the comment section on the live chat section to send us your comments, to send us your questions, to send us whatever else you believe that will be a contribution towards this topic. But before I go ahead and delve into this petition, I would like to request that you subscribe to this channel, you like this video, and you also share it. So without wasting much of your time, because I know you're using data and some of you might be busy somewhere, I'm going to go through what the document that we have is 5 pages, as I've said, and it has to be confirmed as a CCC document, but we got it from some of our sources within that particular party. It says eroded remedies, Article 11.7.1 of the SADC Principles and Guidelines Governing Democratic Elections reads as follows. Post-election period 11.7.1. During the post-election period, the SADC Election Observer Mission shall observe the conduct of procedures and processes during electoral complaints and challenges by citizens, prospective voters, and those seeking election, including the provision of effective remedies for violation of electoral-related rights. Inherent in this principle is that domestic remedies available in terms of the laws of a member country must be effectual. So this is their preamble. An aggrieved party who can show that domestic remedies are not effectual is not obliged to exhaust them. Domestic remedies present themselves largely in the availability of judicial remedies. It is those that must be evaluated before a party can be required to exhaust them. In the case of Zimbabwe, those remedies are not available at all. The Zimbabwean judiciary is fully and faithfully captured. Infamously, Emmerson Mnangagwa has bragged that he is the army, the police, and the judiciary, a claim typified by the continued incarceration of Citizens Coalition for Change, CCC senior official Job Sikala, on trumped-up political charges which were meant to exclude him from the elections. Indeed, one of CCC candidates, Godwin Hakata, won the National Assembly elections whilst in prison, having been arrested for taking part in a car procession on his way to a sanctioned rally. Zimbabwe lacks a functional separation of powers. The executive fully controls the judiciary, and that has been enabled by a skewed appointment system in terms of which Mnangagwa has staffed the courts with his sympathizers. Though Zimbabwe has a public interview system that precedes the appointment of judges, it is an open secret that the results of those interviews have been religiously ignored. This lack of separation of powers has led to the politicization of judicial institutions. Various judgments have come out of the courts show beyond any doubt that the judiciary is disposed towards Mnangagwa and does not consider itself bound to the constitutional ideal of independence. For this reason, even judges whose behavior has been errant have, upon pledging loyalty to Mnangagwa, been spared from giving account. A case in point is that Justice Chinamora, whom the Judicial Service Commission recommended must face a tribunal arising out of clear misconduct. Though Mnangagwa is constitutionally enjoined to appoint such tribunal, he has not done so to date. Going into the elections, Justice Chinamora had more than 10 electoral challenges found in all against the challengers, and is definitely paying back Mnangagwa for his decision to protect him. In that regard, it must be noted that the Chief Justice designated all High Court judges as Electoral Court judges, but only a handful, being not more than 5 judges, had matters in the Electoral Court. The following, however, puts beyond any doubt the fact that no judicial remedies are available to the CCC in the aftermath of the disputed non-election of the 23rd August 2023. So they go on to go case by case. That is, they mention the Chief Justice. In terms of the Constitution of Zimbabwe 2013, Chief Justice Malaba that is Chief Justice Luke Malaba, ought to have tried on the 15th of May 2021 ought to have retired on the 15th of May 2021 when he turned 70 years. In a bid to ensure that he would be available to deal with any electoral disputes in 2023, having come to his aid in 2018, Mnangagwa unlawfully amended the constitution and extended Malaba's retirement age to 75, the first time a whole constitution was amended to accommodate one person and a judge at that. The extension was a fool's errand because in terms of the constitution, any extension of a term limit must not benefit the incumbent. The matter was litigated upon. The High Court paid 3 judges, all of whom have now been victimized in various ways, held that Malaba's term could not be extended and he was obliged to proceed on retirement. Mnangagwa's government was incensed and responded through the Minister of Justice in contempt of court and issued various threats to those and other judges. In a bid to rescue Malaba, Mnangagwa had a third party bring litigation before the Constitutional Court, which sought to nullify the judgment of the High Court. This notwithstanding that Malaba and his fellow judges who had been cited in the litigation had appealed to the Supreme Court. Notwithstanding that the Constitutional Court judges were cited in the litigation and had exercised their right to appeal, they sat as a court in a matter in which they were interested and nullified the judgment of the High Court. As a result of this judgment, Malaba has continued in office. In the run-up to the elections, Malaba issued orders in chambers in the Kasukuwere matter without hearing parties. He solely dismissed applications that could only be dealt with by 7 judges. He has shamelessly played the part for which he was hired. In any petition, Malaba will be the one to sit in judgment. He has already played his hand in a manner consistent with the unlawful extension of his tenure. It is inconceivable that having had his tenure extended by Mnangagwa under these unlawful circumstances, he could turn against him in the most crucial matter of Mnangagwa's political career. As it happens, a few months before elections, Malaba was the first to receive undue gifts from Mnangagwa's administration in the form of an ex gratia payment of close to $500,000. This is in direct breach of the principle of the independence of the judiciary. That the gift was received straight from Mnangagwa's Minister of Finance and not from the Judicial Service Commission does make a bad situation worse. So that is what they have against the Chief Justice. Then the second case is the case of Bharat Patel, one of the judges who wrote the Constitutional Court judgment which nullified the High Court judgment which had found that neither Malaba nor any of the Constitutional Court judges could benefit from the extension of tenure was Bharat Patel. 7 months after writing the judgment, Patel became its first beneficiary and had his tenure also extended by Mnangagwa. He continues to sit on the Constitutional Court bench and is one of the judges who must hear the presidential petition in the event of it being filed. Patel, just like Malaba, had his tenure extended for purposes of the 2023 electoral litigation. The bribed judiciary, that is their third case. Just a couple of months before August 2023, all judges of the Constitutional Court received an ex gratia payment from Mnangagwa's Minister of Finance. They received some $400,000. These payments are not part of their conditions of service. The payments are not loans. No agreements of whatever nature were signed by them, and the nature of the arrangement has been left deliberately fluid. These are bribes, and the fact that they were received some few months before the elections is telling. This matter has been raised in Parliament by Themba Mliswa, then an independent member. Now, all these judges are expected to sit in judgment and deal with the matter that affects their benefactor. Who recently gave them undue gifts. As it happens, 5 of these judges also received payment from Metbank in 2018 after the presidential petition hearing. These payments were also never part of their conditions of service and have to this very day not been declared. So this is the other matter. Then they bring up a case of bogus electoral judgments. Leading to August 2023, a lot of litigation bearing on the conduct of free, fair, and credible elections was brought. All the matters bar one, that is the Bulawayo 12, and even then on appeal and after a massive pushback, produced bogus judgments. As far as the Constitutional Court is concerned, it was predominantly seized with the Kasukuwere matters, which were all resolved on bogus grounds. These challenges brought are key because they speak to some of the matters that must of a necessity be raised in any petition. A brief rundown of some of the matters is imperative. And then they go on to point out the matter of Markham versus the Zimbabwe Electoral Commission. This matter was brought by an opposition parliamentarian who enforced his right to a voter's roll. The application was dismissed, although the Electoral Act, Chapter 2, subsection 13, makes it clear that any Zimbabwean is entitled to a copy of the voter's roll. The voter's roll that was used in the elections was not given to candidates. The second case, Monzora versus Zimbabwe Electoral Commission, this is a matter brought by one of the opposition leaders in which he challenged the delimitation exercise. The application was dismissed, although all political parties concerned accepted that the delimitation exercise was unlawful. In dismissing the applicant, the court did not say the delimitation exercise was lawful. Statutory instruments and amendments to electoral laws. The Mnangagwa administration sought to amend the constitution through a statutory instrument after the proclamation of the election date. Two issues arose. First, a statutory instrument could not amend the constitution. Second, no law could be amended for purposes of elections once an election was proclaimed. Notwithstanding its clear merit, one of these applications failed and the other is yet to be determined. Next was the security cantonment case on ring fencing Dzivarasekwa barracks. It too failed. Mangwana versus Kakusukuwere. This is a case brought by ZANU-PF, a ZANU-PF activist, which sought to bar a presidential candidate from contesting in the elections. The former ZANU-PF candidate enjoys support in the Mashonaland provinces, and his participation would have made rigging in those provinces difficult. The relief granted in this matter strengthened Mangagwa's hand, with the Bulawayo 12. 24 cases were brought seeking to bar the Bulawayo 12 from contesting. In the High Court, the applications were granted on bogus grounds. What is even more illuminating is that the applicants, all ZANU-PF activists, relied on documents that the CCC had no access to and which they could only have been given by the ZEC. Double candidates. During the nomination process, FAZ, that is the Forever Associates of Zimbabwe, a shadowy group aligned to ZANU-PF, launched nomination papers on behalf of certain individuals in order to create double candidates. The double candidates plainly admitted that they had not paid nomination fees and were accordingly not involved in the process of their nomination. Indeed, when a challenge was brought, FAZ procured for all of them legal representation by a single firm of legal practitioners. Although their nomination had nothing to do with the CCC, upon a suit being brought by the CCC seeking a declaration that they were not its candidates, one of the electoral court judges who has a complaint pending against him heard the matter and dismissed the application. An appeal was lodged by the Supreme Court, but the Supreme Court flatly refused to hear it and even rejected heads of argument that had been filed by the CCC. Resultantly, there were double candidates during the elections to the prejudice of the CCC. Final voters' roll case. The voters' rolls given to candidates had discrepancies with the list of polling stations issued, which made it clear that this was not the voters' roll that was going to be used during the elections. This matter was placed before the same judge who had heard the first voters' roll case, and once again, as he had done with the first one, dismissed it. Observers. Certain local observers were barred from exercising their functions on bogus grounds. A challenge brought by them was unsuccessful, though the action taken against them was both unlawful and unprecedented. The rallies. The CCC had more than 110 rallies barred in the run-up to the elections. Challenges brought against these bars failed. In certain instances, courts would sit down the challenges on dates that were after the scheduled rallies. This was particularly the case in Pindura, where the CCC was meant to have its election launch rally. Bail denial. In Seke constituency, CCC members, including a chief election agent for a candidate, were assaulted by ZANU-PF officials. When they sought sanctuary from the police, they were promptly arrested and denied bail. They continue in custody. On the other hand, ZANU-PF officials who murdered a CCC supporter lawfully going about his own business in Glenview were all admitted to bail. Cheza, a losing CCC candidate, who narrowly lost to a ZANU-PF candidate, to a candidate responsible for the disappearance of a police officer who had refused to be used by ZANU-PF, is himself in custody over flimsy complaints, having been arrested a couple of days after elections. Ballot papers case. Contrary to its statutory obligations, ZEC did not advise political parties of the details relating to the printing of ballots, their number, and related issues. When it was taken to court, it undertook to avail those details by the 19th of August 2023. It then purported to give such details on the 18th instant, but refused to produce the serial numbers. Elections were held before this matter was finalized, and it is now known that whilst ZEC claimed to have printed ballot papers, there were no such ballots in all opposition strongholds on voting day. Inauguration. To crown this all, the Chief Justice has officiated at the inauguration ceremony before the period set by law for a challenge to the presidential election has elapsed. All these cases demonstrate a pattern all too perceptible, and which it would be ill-advised for the CCC to ignore. Political judges, that's the next issue raised. On the 7 judges in the Constitutional Court, 2 of them sat in the MTC matter, which led to the eventual enforced formation of the CCC. Although the MTC had held its elective Congress, these judges held that in the interest of democracy, it had to go back to its 2016 structures. The idea was to remove Chamisa as leader of the MTC, who had defeated Mnangagwa in the 2018 elections. What is largely of concern is that this unacceptable judgment was handed down when the country was under a complete lockdown. Courts were closed but were only opened for purposes of handing down that judgment. This was a deliberate move meant to ensure that no protests would attend upon the handing down of the judgment. The judges had this for a consideration and were prepared to break the law in order to contain a reaction. That judges had this for consideration and were prepared to break the law in order to contain a reaction cannot be got over. The circumstances show that these judges are unfavorably disposed against the opposition in general and Chamisa in particular. The 2018 petition. The judges who must hear any petition in the year 2023 are the very same judges who sat in 2018 and produced a controversial judgment in favor of Mnangagwa, which has been criticized by academics and judges alike. The Supreme Court of Malawi emphatically refused to follow the judgment, which has received worldwide condemnation. There is no chance that these judges could dispense any justice this time around. Threats. Apart from being naturally beholden to Mnangagwa, the Constitutional Court judges, just like all other judges, are routinely threatened by the Mnangagwa regime. The statement issued by the Minister of Justice is a case in point. It is of significance that even SADC has itself received threats from the Mnangagwa regime. The matter is exacerbated by the fact that Zimbabwe is a securocratic state. SADC and other missions on observations. SADC has its own report properly noted that the legal playing field is not even and that the judiciary is fully captured. This has been the case with reports by other missions. Summation. For all these reasons, the Citizens Coalition for Change cannot expect an impartial hearing from Zimbabwean courts. For that reason, there are no domestic remedies available. So that is their case for why they have not gone to any Zimbabwean court to seek a remedy as is expected or as is required by Zimbabwean law. So they've given a reason why, or an argument why they cannot go to seek any remedy from the Zimbabwean courts. And now, this is the case that we have. We don't know if this is in draft form or this is what they want to take to SADC, because if it goes like this, it only speaks to why they didn't call to the Zimbabwean courts to seek solace or to give a reason for their petition or to prove that there were gross irregularities in as far as the hanging of the election that just ended in Zimbabwe is concerned. If this is the only document that they're going to submit, I don't foresee how or why this should be considered for an argument for fresh elections, but they do give a strong case as to why they didn't go to the Zimbabwean courts. We have to give that to them. The case is very strong, and they mention a number of cases which prove that a number of cases that they brought to the Zimbabwean courts have been ruled against their favor or have been ruled in favor of the incumbent, which proves that, as per their argument, the courts in Zimbabwe are not independent. The courts in Zimbabwe are partial. The courts in Zimbabwe are against the opposition, in that the courts in Zimbabwe are for the incumbent. But I don't know why they have to mention the issue of Sevia Kasukwere, especially the political guesswork, let me say, or political belief that Kasukwere would have drawn some votes from ZANU-PF. There seems to be, one way or another, an attempt by CCC to try and force Kasukwere's candidature into the election or whatever fresh election that they might get, with the hope that is going to take away some votes from ZANU-PF, some votes from Nangakwa, and parcel them or reduce the margin between Nelson Chamisa and Emerson Mnangagwa, or rather, or in a way, present or gift rep a victory to Nelson Chamisa. I don't know. It cannot be a legal argument. To them, it's a political argument that they're trying to factor into their legal case. I don't know. So this is what we had. We, like I said at the beginning of this broadcast, we have not yet been given confirmation by the party's official channels that this is indeed a case that CCC has presented to the SADC or hopes to present to the SADC. If it is, we believe that it is insufficient and has to be followed or accompanied by another which speaks to the holding of the elections and the irregularities that were found as per the running of the Zimbabwean elections, because we don't believe that the SADC election observer missions report would suffice, because the CCC would have to present its own case based on what they have as a party. They may make reference to the SADC election observer mission, but also they must have their own prepared case, which speaks to the gross irregularities from a party that participated in the election. And this must be a very strong legal case. It must be very strong if they want to push for a fresh election. But what we foresee is that whatever is going to be brought to the SADC, if it doesn't fit into a grossly manipulated election in Zimbabwe, can only be used to try and foster in reforms going to 2028. And as we have said before, I don't foresee the Zimbabwean election being nullified, and I don't see why SADC will have that power to nullify an election in Zimbabwe when the same SADC is failing to force King Mswati to allow the opposition to freely contest elections when it has failed in several other countries to force governments there to go to hold another election or a fresh election when there are no legal provisions for the SADC to force a member state to go to another election, and when membership of SADC by member states is voluntary. Zimbabwe can move up out of SADC. It's possible. It would have dire consequences, but we have seen before that ZANU-PF doesn't care at all about the livelihoods of Zimbabweans, and they don't care about the economic downturn that the country might get from these unilateral activities or arbitrary decisions that they might take. So I don't foresee SADC in any way, even if coming up with a unanimous decision to force Zimbabwe to go to a fresh election, how they will be able to enforce that. And that is another issue. The main problem is that the SADC itself is not singing from the same hymn book in as far as the Zimbabwean election is concerned. You've already heard Fikile Mbalula coming out openly to say that a win by ZANU-PF is good for the SADC, it's good for South Africa because it is a defeat of Western puppet. You've heard the SADC, the Namibian ruling party, and there's a Namibian observer mission saying that there is a concerted effort to try and defeat former liberation movements in Africa. You've seen them, the Namibian president congratulate President Mnangagwa for winning this election. You've seen Tanzania congratulating the president, Emerson Mnangagwa, for winning this election. I'm not saying they're wrong. They've got their own reasons because the argument for a rigged election have been held, but they have not been certified by any court of law to be holding any water. So we have seen also the president of Botswana congratulating President Mnangagwa. So this shows that SADC itself is not going to rule unanimously. In this case, it's not going to argue this case unanimously. So I don't foresee any fresh election in Zimbabwe, but my hope is that whatever comes out is going to force the Zimbabwean government to hold a free and fair election under a level playing ground going to the 2028 election. We're looking forward to the democratization of Zimbabwe, to the independence of the Zimbabwean Electoral Commission, to the independence of the judiciary in Zimbabwe. And now, as we go ahead, we know that the new parliamentarians will be sworn in tomorrow. This is the time for opposition parliamentarians to start arguing a case for especially the independence of the judiciary, because that is where cases are being won and lost, and that is where the fight for the democratization of Zimbabwe is being lost. So if we have an independent judiciary, everything else is going to fall into place. Thank you very much. This is what we had for you. Keep your questions coming, keep your suggestions coming, keep your comments coming, but at the end of the day, don't forget to subscribe to this channel, like this video, and share it.